All right, guys, I welcome you live on SVTV Africa, SVTV International, live on Facebook and our YouTube channel, SVTV International, also on our other YouTube platform, SVTV Africa. My name is DJ Nyame. Welcome on board. It's Friday. Thank God it's Friday. And I'm here with Lawyer Wisdom, Akao Wiseman Solicitors, straight from the UK Matters. Let's go straight today. No long talk. Let me go straight and introduce Lawyer Wisdom Akao on board. You're welcome. Make sure you share our live session. Drop your comments at the comment section. You can ask Lawyer any question that you want to ask him. When the time is up, we'll drop your questions so that Lawyer will answer you. So you are welcome on board. Make sure you share this live. Breaking new matters and breaking news and all other matters. We are coming to talk about it today with Lawyer Wisdom, Akao Wiseman Solicitor. Let's go straight. If you are watching us on Facebook, make sure you share this live section. If you are watching us also on our YouTube channels, SVTV International English channel and SVTV Africa, make sure you share it. Drop your comments and then invite your friends to come and join us. Let me go straight and invite Lawyer Wisdom Akao on board. Lawyer.
Hello, DJ.
Yeah, how are you doing?
I'm very
Boss?
well. Yes, you are the boss. How are you?
Everything is fine here. We thank God. how about you in the UK? Are you in the UK or you are in Studio B? Let me see. Oh, now we are talking from Studio A. Me, I know the background. Oh. So you are talking from Studio A. This time is not Studio B. Welcome back to Studio A.
Thank you very much, my brother. How are you?
Yeah, I'm doing good, Lawyer. So let's go straight to the topic for today. I mean, about this asylum seekers that they are sending them back to Rwanda. I think we've
Yes.
discussed this thing before, but finally, I heard the bill has been passed.
Yes.
So, any updates from that? And then, what can one do? I mean, if you are part of the asylum seekers, are you coming to? If you are from Ghana, you are from Nigeria. Are you coming to Nigeria, or you tell them that okay, I want to come to Nigeria. I don't want Rwanda. What about that? Let's say I don't want to go to Rwanda. I want to come back to. I want to come back to my country. Is it possible? Okay, Lawyer, it's over to you. So let's hear from you today.
Okay, thank you very much, and good evening to all our listeners. I hope we are all doing very well. Thank God for another Friday. Well, DJ, I mean, you and I know that there's been this issue with regards to removing asylum seekers to Rwanda. Now, it was sometime last year, it's been going on, and ultimately, the government at the point wanted to take some people to Rwanda because it had come to a certain agreement with Rwanda to remove asylum seekers, to take them to Rwanda, and to process the application before bringing them back to the UK if they are successful on the application. But the case went to court, and the Supreme Court actually, uh, through the judgments, stopped the Home Office from carrying out the removal flights, the taking people to Rwanda. But the government, parliament, is determined to actually enforce or take the asylum seekers to Rwanda. In fact, the if you look at what the government says in the legislation, that is the Safety of Rwanda into bracket Asylum and Immigration Act 2024. Safety of Rwanda, Asylum and Immigration Act 2024. This is what it says. It says the purpose of the act is to prevent and deter unlawful migration. The purpose of the act is to prevent and deter unlawful migration, and in particular, migration by unsafe and illegal routes, by enabling the removal of persons to the Republic of Rwanda under provision made by or under the Immigration Acts. So these are the reasons for this act. The act is Safety of Rwanda, Asylum and Immigration Act 2024. And it says the purpose is to prevent, one, to prevent and deter migration, to prevent and deter people from coming to the UK. And
Lawyer, hold on for me, guys. I apologize. We have been off for the past 5 minutes. Power, Charlie Ghana, we are facing this doomsaw thing. So we went off, but we need to turn generator on. So now we are using generator, but there's light off. You guys should, if you are in Ghana, you know the situation now. This light off thing is disturbing us. So they just off our lights. So we have been off. So all what you said is didn't go anywhere.
Yawa.
All what you said didn't go anywhere. I'm sure those who are watching will notice that we have been off. So we are back now. We are running on gen set, so we are good to go now. So guys, forgive us if you are watching us from Ghana. You know the situation already. Doom so you know the situation. It's not a news, but if you are not in Ghana, probably then I have to let you know that this is what we are facing now. So lawyer, let's start again. After I introduce you, then the light went off. So
Thank,
you can start again with the asylum seekers and what we can do and all that. I mean, so over to you. Let's go. Now we are okay. Let's go.
thank you very much. Thank you. Apologies for the break in communication by virtue of the lights out in Ghana. Apologies. Right. So I was talking about the removal of asylum seekers to Rwanda. That was the government's project, particularly to prevent people who were coming with the boats across the sea to the UK. And lots of people were coming with the small boats, and several people died, perished in that trip. So the government got to a point, it became overwhelming, and to the extent that the government decided to uh, obviously, when they come to seek asylum. The government therefore decided to prevent and, of course, stop the small boats by going into agreement with Rwanda so that people who come to claim asylum here would be taken to Rwanda and they'll be processed there. Once you are processed in Rwanda and your case is deemed to be valid or you should be granted asylum, then you will be brought back to the UK to be, of course, granted your leave to be here on the basis of your asylum. Now, the government initially intended to do the first removal, but that was stopped because the case proceeded to court and the Supreme Court, by virtue of the decision, their judgment, so the court ruled that it was unlawful to remove anyone to Rwanda, and therefore nobody could be removed at the time. The government being determined to, at all costs and by all means, implement its decision or go ahead with the removals to Rwanda, again, because of the agreement they had reached with Rwanda, they took the matter to court, took the matter to parliament. They made a lot of changes. At a point, it was defeated in the House of Commons. It went to the House of Lords. It was defeated there, and then certain changes had been made, and eventually the bill passed. It was passed, and then it has received royal assent. From my understanding, the king has signed it, and it is now law. Now, what uh, the bill or what the law intends is that the Home Office says the purpose of the act is to prevent and deter unlawful migration. So one is unlawful migration. It does not affect people who are coming to the UK lawfully. This act does not affect people who are coming to the UK lawfully. So it says is to prevent and deter unlawful migration. That is one. Two, and in particular by unsafe and illegal routes. So people who are coming to the UK by unsafe, that is on the boats, and illegal routes, that is by coming in a van or in a truck or by any other means that is illegal, that is the purpose of the act. That is by enabling the removal of persons to the Republic of Rwanda under provision made by or under the Immigration Act. So, to prevent, to deter people who are coming to the UK unlawfully by illegal routes, that is the purpose of the act that the government has now brought in. So, of course, the Supreme Court raised some grounds or reasons why the government cannot remove anybody to Rwanda at the time. Now, the Home Office claims that they have responded to the Supreme Court's concerns. They claim they responded to the Supreme Court's concerns, and therefore they have. This is what they have said. Now, to advance that purpose, the Rwanda Treaty has been laid before Parliament under Section 20 of the Constitutional Reform and Governance Act 2010. That treaty is laid before, and this act gives effect to the judgment of Parliament and that the Republic of Rwanda is a safe country. So, this is what the government is saying. So, the government is saying the removal of immigrants, the removal of asylum seekers to Rwanda, and Rwanda must be considered as a safe country. The government of the Republic of Rwanda has, in accordance with the Rwanda Treaty, agreed to fulfill the following. So the government of Rwanda has agreed to fulfill the following. One, the Supreme Court raised a concern that people will be taken to their country from Rwanda, which is what we call refoulement. Refoulement means if your application is not successful, the Rwanda government can take you back to your country. But the Home Office claims that they will not do that because the Rwanda government has agreed not to do so. But serious concerns have been raised. Serious concerns have been raised from international uh, organizations, from the United Nations. And it says the new legislation in the UK marks a further step away from the UK's long tradition of providing refuge to those in need. The UK is now stepping away from providing refuge for those in need. That is one. And also, the UK's convention or the UK's act now is in breach of refugee convention. It means the UK doesn't want to take responsibility. The UK does not want to take responsibility. They want to push their responsibility to other countries. They just are dodging responsibility by pushing their responsibility to other countries, which to them is quite unfair. And it says protecting refugees requires all countries, not just those neighboring crisis zones, to uphold their obligation. Now, if the UK doesn't want any refugee to come to them, they want the refugees to be in France or any other country that is shirking their responsibility or being not responsible or not wanting to take up responsibility for refugees who may need true help. So they called on the UK government to reconsider its plans, to call on the UK government to consider its plans, adding that the UK has a proud history of effective independent judicial scrutiny and it can still take the right steps. But unfortunately, the UK has not complied or listened to all the pleas of these international institutions or international representatives, and the UK has therefore decided to go ahead with its own plans, and therefore this law has now come into effect. So the bill has received the royal assent, as I understand, and therefore it is now in law. This is what the Home Office is saying. claim is. The Home Office is saying yes, even though the court had raised certain concerns. One, Rwanda has agreed that any person removed to the Republic of Rwanda under the provisions of the treaty, a relocated individual, will not be removed from Rwanda except to the United Kingdom. So, this is what they are saying. If anybody is taken to Rwanda and their asylum is processed and they are deemed to be eligible for asylum, the UK will issue them, they will come to the UK. However, if anybody has been taken to Rwanda and they are not successful, Rwanda will not take them to another country except to the UK. So that is what it is. That anybody who has been removed to the Republic of Rwanda under the provisions of the treaty will not be removed from Rwanda except to the UK. So if Rwanda has to send anybody anywhere, they will not send you to Nigeria, they will not send you to Ghana, they will not send you to Cambodia, they will not send you to South Africa, they will not send you to Zimbabwe. They would only send you back to the United Kingdom and not to your country from where you are fleeing. And therefore, what the government is saying is that the Supreme Court's concern of refoulement will not arise because Rwanda has agreed that they will bring anybody to the UK. They will not remove them to any other country except to the UK. Two, any relocated individual is to be made available to return to the United Kingdom following a request from the government of the United Kingdom. If anybody is in Rwanda and that the UK requests that the person should be returned to the UK government requests as such, they will be brought back to the UK, not again sent to another country. So that is number two in the obligations of the treaty from Rwanda. Number three, that the system for processing of protection claims by relocated individuals is to be improved. That is, the system for processing of protection claims by relocated individuals is to be improved. What that improvement means, we don't know. Nobody can tell what it means that it will be improved. The Supreme Court said that Rwanda did not have the legal system which would enable it to make decisions fairly without political interference. Here, the law is saying that the that is from what we have in front of us, we have in us in law now. It says the system of protecting claims by people who have been taken to Rwanda will be improved. What the improvement means, nobody knows. What systems have been put in place to protect them, we do not know. That is what the situation is right now. Number four, that relocated individuals are to be treated equally, irrespective of the status that they are granted in the Republic of Rwanda. So if you have been removed from the UK to Rwanda, Rwanda has undertaken that you will be treated equally, irrespective of the status that they are granted in Republic of Rwanda. If you have been granted an asylum refugee status in Rwanda, Rwanda claims you will be treated equally. Equally. As for what that means, we are waiting to see. And E, that relocated individuals are to be provided with legal assistance for the purpose of their protection claims and any appeals relating to such claims. What the law is saying is any person who has been removed from the UK to Rwanda, they will be provided with legal assistance. That was one of the concerns of the Supreme Court. That the system there, the refugees or people who are seeking asylum may not get legal representations. Now, what the government is saying is that anybody who will be removed to Rwanda will have legal assistance. But the question is, the legal assistance they will have, will it be of the same quality and level as they would have received if they were here in the UK? That is a huge question. Besides that, who is going to be paying for the cost of processing those claims in Rwanda? Who is going to be responsible for paying the costs? The lawyers in Rwanda, are they familiar with asylum situations or cases? What sort of trainings do they have? What shows that they will give the best possible advice or provide the best possible legal assistance? These are all questions that still are outstanding. So that is what the claim that the government has provided. Then the next one is that um, it is recognized that the Parliament of the UK is sovereign and the validity of the act is unaffected by international law. And therefore, what they are saying is the law is valid. Even though international organizations and international laws are concerned, the UK is saying our laws are valid, and the courts in the UK is the United Kingdom is sovereign, that the UK, the United Kingdom, is a sovereign country and it has the right to make all its laws as it pleases. So these are some of the purposes for the law which has been passed. But the assurance anybody can have right now is that even if you are sent to Rwanda, at least you have the assurance that you will not be taken back to your country where you are fleeing from persecution, that you will be tortured or anything of the sort. At least the assurance is you will not be taken to your country where you are running away from. If anything at all, you will be returned to the UK. We are yet to have any confirmation because it hasn't started yet. We are yet to know whether or not what the law says is what it will be. Several times, some of these laws are, of course, brought into effect, but it is subject to a lot of challenges. Now, if anybody has been subjected to any torture, etc., in Rwanda when they go there, of course, it gives them the right to challenge the decision of the of the country. But now we want to know, does a person who has had any treatment in Rwanda, who feels they've been unfairly treated, do they have the right to appeal through the court system all the way to the Supreme Court in Rwanda, or they can appeal to the courts in the UK? These are things we don't know yet. We will wait to see because it will be tested in court to see whether anybody would actually be brought back if they have not been successful in their appeals in Rwanda. We don't know. There are so many unknowns, so we have to wait to see how this it will be. So actually, it was on the 5th of December 2023, the government of the UK and Rwanda signed a new treaty. So that is the treaty that has been now been put into law, and therefore, uh, if you are seeking asylum, you want to seek asylum, or you're coming to the UK to seek asylum, I would say it is not a very friendly environment right now, unless you have a genuine case, strong case that you know could succeed. I would strongly say you have to seek legal advice so that you don't expose yourself to being taken to Rwanda, where you may not get the best possible representation, or come to the UK back if your application or you are seeking for asylum, you sought for asylum is successful. We cannot say for certain when or if this rules will actually treat anybody fairly. We can't. We can't. Now, this is what it says. The Prime Minister says, yes, that the first flight to remove asylum seekers to Rwanda will be within 10 to 12 weeks, 10 to 12 weeks from when this has received royal assent. And there will then be a regular rhythm of multiple flights every month over summer and beyond until the boats are stopped. So that is what it says. The first flight will be between 10 to 12 weeks from now, and then there will be regular rhythm of multiple flights every month over the summer and beyond until the boats are stopped. Even though he is referring to just the boats here, people who are coming with the boats, it does not mean that it's only the people who are seeking asylum through or coming through the boats that will be dealt with in this way or be treated under this rule. Anybody who is seeking asylum can be taken to Rwanda because there is nowhere that it says the people who have already sought asylum will not be removed or will not be taken to Rwanda. So, if upon assessment of your case it is deemed that probably you have no merit in your case, you can just be added to the list of people who came with the boats and be taken to Rwanda. So, I would advise that if you are an asylum seeker, if you've sought for asylum, in the UK. Your case is being processed. Your case hasn't succeeded yet. And you are in the UK. I would ask you to go back to your legal representatives. If you have one, if you have legal representative or legal representatives, please go back and sit with them to reassess your case so that you can get the best possible advice as to what you should do, as to what you should do, as to what steps you should take whilst your appeal or your asylum claim is still pending. So I would again strongly advise anyone who has sought asylum or who wants to seek asylum to please go sit down with your legal representative and again get clarification as to what the implications of this are, whether you'll be taken to Rwanda or you will be made to remain in the UK. There's a huge asylum backlog, huge, and nobody knows when that will ever be completed. So this is all for your attention that between the next 10 to 12 weeks, the first flight is going to take effect, and then there will be regular rhythm of continuous removals until the boats are stopped and until the backlogs are cleared. I am very certain that this act is to just check, is to just push the UK's responsibility to other countries and not wanting to take or being able to or wanting to actually not wanting not being able but not wanting to be responsible for asylum seekers who are coming to the UK to seek for refuge. So this is the update that I want to put out there. Let me summarize it by saying if you are an asylum seeker, the bill has been passed. It is now law. You need to go back to your legal representative and ask what next. They would advise you as to what steps you should take. As to what steps you should take. If you wish to be taken to Rwanda, what step you should take. If you don't want to be taken to Rwanda, what is the strength of your case? What step you should take. Please see your legal reps, and I'm sure they will update you on what to do. DJ, it's a
So
serious.
lawyer,
Mhm,
so lawyer, this is a serious issue. So lawyer, if I'm from Rwanda and I'm
mhm,
in the UK seeking for asylum, where
mhm.
would they take me to?
That is a very good question.
It's because I'm from Rwanda
Yes,
already, and I'm in the UK seeking for asylum. So where would they take me to?
and we are claiming that Rwanda is a safe country. So
We have some people from who are from there that they are also seeking asylum.
obviously there will be people from Rwanda. There is just it's just not possible that not a single person in the UK is claiming. So by all means, amongst the people who are claiming asylum in the UK, there will be one or two or a few or a lot who are from Rwanda. The question then is, where do you take them to? Because they are running away from something from that country. And that is why I said there are a lot of unknowns in this case, a lot of unknowns. Maybe they will be kept in the UK and their case will be processed here until
But that would
everything.
not be fair. If they will keep them in the UK, then that would not be fair. Why are they
Well,
keeping them in the UK?
Well, the UK, you never know, may want to strike a deal with another country and then take the Rwanda South Africans to that country. And once they are processed, they are safe. And
But yeah, this thing is disturbing. I mean, if you are from, especially those who are from Africa, that they are seeking for asylum in the UK.
yes.
I mean, if I want to go to Rwanda, I can just go. Why, taking me back to Rwanda? I mean, if I'm from Africa, I can just go and visit Rwanda and come. If I want to go there, why are you sending me there? We know our way to Rwanda. We know our way there to Rwanda. You're
No,
not the one to show us Rwanda.
the UK government wants to show you that Rwanda is a safe country. So if you want to seek asylum, go to Rwanda. In fact, I I understand they've contacted some other countries to do this, and the countries say no. I don't understand why, and I don't know the reason behind why Rwanda alone accepted to do this. I have no answers to that. But some other countries have declined to back the UK in this drive. But Rwanda, for whatever reason, you and I don't know, have agreed to accept the asylum seekers there. It's new. Just like every new law, it evolves. Takes time, new things come, it goes to court, they're challenged. So let's see how this one will progress. If it will progress, we will know. You never know. If another government comes, whether this one will be, repealed or whatever it is, we wait to see if there will be any change as we go along.
But it's not going to be easy for Rwanda for accepting this in future. From the look of things, that's how I see it.
Yes.
Yeah, it's not going to be easy for them. For now,
I
maybe they have not thought about it, but when they start sending people there, then maybe they will understand some
the
things. But
implications.
for
You're
now, I
right.
don't know. Yeah, there will be some implications in
Yeah.
future, not now.
I agree with you. I agree with you. When this takes effect and the volume of people that will be sent to that country, the number of people that will be taken out, like the Prime Minister has said, he says there's going to be what? A regular rhythm of multiple flights every month.
Hmm.
Regular rhythm of multiple flights every month. So it's not going to be one flight a week or one flight a month. Regular every month. So it can be two flights, it can be three flights, it can be now just imagine even 100 people being sent every week. Just imagine. There are
Hmm.
resources. There are resources. Are the people just going to be there without working? If they're not working, how are you going to be fed? They're going to be fed. Are you just going to keep them in a camp? Are you going to give them provide housing, etc.? Are you going to prevent them from going to town? Some of these people, what is their criminal record? Do you know these people? It's going to be all kinds of things. Assuming some of them are criminals. I'm not saying they are. I'm not saying. I'm just conjecturing. Assuming some of them have criminal records. Now you've taken them there. The Rwanda system, their police force, their military, are they able to cope with these people? Armed
Hmm.
robbery, all kinds of things that will take place. Are they able to accommodate this? Now, if you are sending an asylum seeker to Rwanda with their children, their educational system, are they going to get schools to attend the children? Their medical system, their hospitals, are they going to have these facilities? It's a huge matter. And like you and I are saying, Rwanda maybe for whatever reason have accepted it now. But as time goes on, I am very sure there will be serious answers, questions to be answered.
Okay, lawyer. So let's move to the other topic. You were talking about some EU nationals.
Yes. The question is EU nationals. I have heard from several sources EU nationals can no longer bring their family members to the UK. That is what I've heard. And I've had questions. People call me, I'm an EU national. I hear that you can't bring your family members to the UK anymore. Is it true? I just want to take this opportunity to address this and address it once. and for, I believe, all. Number one, all EU nationals who are still in the UK. If you're an EU national and you are not in the UK and you haven't registered, you don't have a settled status or pre-settled status, you are clearly out of this discussion we are having. But if you're an EU national, you are in the UK, you have a pre-settled status or you have a settled status and you are in the UK, you are still able to bring your family member depending on some factors. You are still able to bring your family member depending on some factors. So it is not true. It is not true that EU nationals cannot bring their family members. It is not true. The confusion people are having is this: we need to know, was the person a family member before the UK left the EU? If the person was an EU national, example, the EU national and the person is a family member of the EU national, before the UK left the EU, you don't have any problems. Let me put it this way. If you married the EU national before the UK left the EU, you are still able to bring your wife to the UK. But that application will be made under the EU law, not under the UK law. That is where some people are confused. If you are an EU national, you married before 31st December 2020. Example, you married 2019, 2018, 2020, but before December 31st. Because the marriage took place before 31st December 2020, you are still able to bring your EU national to the UK as your spouse. No problems at all. You can still bring your wife or your husband to the UK under the EU you married before 31st December 2020. If you married before December 2020 and you have an EU passport, you can still bring your wife to the UK under the EU law. You can still bring your partner to the UK under the EU law without any problems. If you have children who were born before 31st December 2020, they are family members and that relationship was existing before UK left the EU. Again, they are able to come to the UK without any problems under the EU law, without any difficulty. So, the key thing is 31st December 2020. That is the key date. 31st December 2020. We have to look at it before, relationship before, and relationships after. Now, so if you married or if you had any family relationship before 31st December 2020, you can still bring your family to the UK if you are an EU national. The only group of people you cannot bring if you are an EU national is if the person is an extended family member. Extended family members are different from family members. Extended family member includes one, your brother, your sister, your nephews, your nieces, your uncle, your auntie. All these categories of people, you cannot bring them to the UK. If you are an EU national, you cannot bring them to the UK. Extended family members, brothers, sisters, nephews, nieces, uncles, aunties, you cannot. Uncles, children, uncles, children, aunties, children, they are all extended family members. You cannot bring them to the UK. But your own family members, wife, wife's children, your father, your mother, your grandchildren, you are able to bring them to the UK without any problem. Now, your children who are under 21 years, you can still bring them without any difficulties. Your children who are above 21 years, you can still bring them, but more likely than not, that is going to end up in court because the Home Office refuses almost all applications for children who are above 21 years or of EU nationals. So you then have to take the case to court to challenge the decision, and the court will then give the final judgment as to whether or not the appeal is allowed or the appeal is dismissed. That is it. So let me just summarize that aspect. If you married an EU national before 31st of December 2020, you can bring them, your family member, to the UK. If you have family members, children, grandchildren, etc., before 2020 December, you can still bring them to the UK. If you have grandchildren, you can still bring them to the UK if the relationship was existing before 31st of December 2020. So all of that. You cannot bring your brothers, sisters, nephews, nieces, uncle, aunties. You can't bring them. As for them, they have been cut off, so you can't bring them. So if somebody is saying you cannot bring your family member to the UK as an EU national, that is not correct. But if they say you cannot bring your extended family members to the UK, that is correct. So the word is extended family member. Extended family members cannot come to the UK. Family members can still come to the UK. So that is that. If you want to bring your EU national family member to the UK, you have to have some documentations. If it is marriage, you don't write the English language test. You don't, because you married before 31st December. You don't do tuberculosis because you are an EU national family member. You don't pay home office fee of £1,920 or so. You don't pay that. You don't pay IHS of £3,220 or more. You don't pay that. So EU nationals and their rules are flexible and very kind in terms of payment. You don't. No home office fee, no IHS, no tuberculosis, no English language test. You can apply to come to join your partner in the UK without any difficulties under the EU law. However, if you are an EU national, you have a EU passport from Germany, Portugal, Spain, Italy, France, or anywhere, you have an EU passport, but but you married after 31st of December, which means you married from January 2021. In that case, you are again able to bring your partner or your family to the UK, but that will be under the UK law, not under the EU law. If you married, you have EU passport. Yes, we agree. You married January 2021. Because the UK had left the EU, your application will be made under the UK law, not under the EU law. So that is the differentiation. In that case, you have to write the English language test. You have to do tuberculosis test to make sure you don't have any infections. You have to pay the home office fee of about £1,920 or more. You have to pay the IHS of £3,220 or more. You have to pay all of this. You have to prove that you have tenancy agreement, that where your partner comes, you will be able to live with them, your partner and your child or your children, without leading to overcrowding. Under EU law, there is no requirement for tenancy agreement. The law does not require that. You don't have to show tenancy agreement under the EU law. Under the UK law, you have to show you have accommodation tenancy agreement, which would accommodate you without leading to overcrowding. So that is that aspect of the rules as well. So with regards to the decision, with regard to the application and the decision, depending on whether you married in 2021 or 2020, that would determine. If you are applying under the EU law, under the UK law, sorry, if you apply under the UK law, you have to prove that you have enough funds, £29,000. Under the EU law, whether you earn £10,000, £5,000, £6,000, they don't really care. They don't care if you're earning anything. But under the UK law, £29,000. So these are the differentiations between the UK law, EU law for the same person who has an EU passport. If you have a EU passport, you can make an application under the EU law if you married or the relationship was there before 31st December 2020. If you have the EU passport and the relationship is after 31st December 2020, you have to come under the UK law. So all in all, it is not accurate to say that EU nationals cannot bring their family members. They can bring their family members, but it depends on the law on which you apply. DJ, I'm sure there'll be some questions on this or possibly other things. I'll be more than happy to respond to those questions. So we can take questions now. Will the years someone has to wait to qualify for British passport reduce if he or she marries a British citizen? Yes, the years will reduce. Now, if you look at section 6, subsection 1 or so of the British Nationality Act 1981, we have requirements for a person who wants to naturalize as a British citizen. Now we have the residential requirements, we have the English language, we have the English and the life in the UK, and good character requirements. Now, under the residential requirements, if you marry a British citizen, the requirement period is 3 years. 3 years if you are married to a British citizen. But when we talk about 3 years, we talk about you had valid visa before you applied, and then you now have your indefinite. If you have your indefinite today, because now you have to apply for 2.5 years twice. The first 2.5 years and then the second 2.5 years makes a total of 5 years. The requirement for partners of British citizens is 3 years. By the time you get your indefinite, you have already done the 3 years. So you do the 2.5 years, another 2.5 years. So by the time you get your indefinite, you've already done the 3 years which is required for spouses of British citizens. So yours is reduced to 3 years. In other words, if you get your indefinite leave today, you can apply for your British citizenship today. But if you are married to a person who has indefinite leave to remain, you have to have your indefinite leave to remain, and you have to wait for 1 year on top of that. That makes it a total of 6 years before you can go for your indefinite, before you can go for your citizenship. So let me say it again. If you marry to a British citizen, after you've gotten your indefinite, you can go for your British citizenship the same day, straight away. You don't have to wait for 1 year. But if you marry to a person who has indefinite leave to remain, then you have to wait for 1 year on top of your indefinite leave, which makes it a total of 6 years before you can go for your British citizenship. Thank you.
Okay, so guys, if you are just watching us, if you just join us, make sure you drop your questions at the comment section. Ask Lawyer any question that you want to ask him, just drop it at the comment section. Don't wait till the time we are about to sign out before you bring your questions. So quickly, you can just drop your questions based on the topics, the EU matters he brought today. As for the asylum seekers, there, I don't think there's any question about it. But apart from that, and any other questions, you can just drop it at the comment section. I'll put it on the screen for Lawyer to answer your questions for you. So any other question that you want to ask Lawyer, you can just put it there, and I'll put it on the screen for you. So Lawyer, let's take this one.
Thank you. All right. It says, what is the age limit for children under the UK law for EU nationals? Now, if you are a EU national, there is no age limit. If the person is a EU national, there is no age limit. The only thing is, children under 21 years, the application is straightforward. They don't have to prove dependency. All they have to prove is relationship. So if you are an EU national, you want to bring your child, and the child is under 21 years, all you need to prove is relationship. You don't have to prove dependency. But if the child is gone past 21 years, then you have to show relationship and dependency. That is the two things you have to show: relationship and dependency. Dependency is where the issue normally arises. That is where surely issues would arise. That is where the Home Office expects to see what money transfer your father sends you, how much money they send you, how much you spend for your living costs, what shows that you are unable to survive without your parents' support. That is where they normally refuse the application, and then they would you have to take it to court to challenge the Home Office in that case. So that is where it stands if you are an EU national. There is no age limit, no age limit for EU nationals and their family members. No age limit. The only difference is under 21, it's more straightforward. Above 21, it becomes difficult, but and you may have to end up in court before the decision is granted by the court. But if you are a British citizen or you have indefinite leave, then it is 18 years. 18 years. Once you go past 18, you are an adult. You are not a child anymore. It becomes difficult to apply for you to come to the UK. Hi, I'm dependent and my spouse is a student. Can I go home and come back to UK? Our BRP expires in October. If we want to bring our children, would they be charged with full IHS fees? Well, if your spouse, as a student, is in education, I would say yes, you can travel back home and come again without any problems if your spouse is still in education. If your spouse is not in education, then that becomes a problem. If he's in education, no problem. You can go home, you can come back. Your children, would they pay the full IHS? I believe there's a reduced IHS fee for dependents of students. So because students normally don't pay the full fee just like everybody else, so their fee will be reduced. Unfortunately, I don't have any figure of head to give, but certainly they will pay a more reduced IHS fee. Yes, thank you. Right. Hi, Linda. What are the requirements to show sole responsibility to bring your child if you have indefinite leave as an EEU family member? Thank you. Now, if you have indefinite leave as an EU family member, my question is this: are you still in a relationship with a EU national? Is it your father or your mother or your husband? I need to know. If you still have the relationship with the EU family member, then it is cheaper, it is quicker, it is more straightforward. Let me use the word easier for your children to come and join you, or for your child to come and join you under the EU law. Just like I said, it is quicker, it is cheaper, it is easier for the child to come under the EU law if you are still in a relationship with the EU national. However, if there is no relationship, assuming you were married to the EU national and the relationship is broken down, you divorce. If you divorce and you now have your indefinite, then you have to come under the UK law, and that is where your question of sole responsibility comes in. Sole responsibility, how do you prove that you have sole responsibility? To prove that you have sole responsibility, the word is sole, just you, and responsibility. You are the only person who is responsible for the child. Now let's come down. What do children need? What aspect of their lives concern the parent? The children need clothing. So prove that you are the one who provide their clothing. Before even the clothing, the children need food. Prove that you are the one who provide for their food, their maintenance. How do you prove it? Money transfer, maybe door to door shipping. All those things will show that you are the one who have sole responsibility. So we talk about food, we talk about clothing. That is very important. Three, children need education. If they are in school, who makes the major decisions with regards to their education, their schooling? Is it you? Yes, how do you prove it? Take a letter from the school. The letter from the school will prove that, of course, you are the one who make all these decisions for or about the child. The school, right? Yes, Madam so and so or Miss so and so is the only parent we have on the record, and she makes all decisions regarding the child's educational life. She calls the school to find out about the progress of the child's schooling, and if there are any areas to enhance, we discuss that with her. So everything is focused on you, the parent in the UK. The other aspect is child needs food, child needs clothing, child needs education, child needs medical needs, hospital. So you get a letter from the hospital or the clinic again to say that you are the only person who is solely responsible for this child. When it comes for medical treatment, you are the only person who give consent before the child is treated. So that is also another evidence. Or maybe you have custody order from the court. If you have a custody order from the court, you use that as well to support your application that you are the only person who is responsible for the child. The child's father has been approached on several occasions and he has decided not to play ball, he decided not to cooperate. They've sent him letters, he has declined to respond. They invited him to court, he doesn't respond. In fact, you have no idea of his whereabouts, you have no idea where he is right now. Therefore, you are the only person. So, child needs school, child needs food, child needs clothing, child needs school, child needs hospital or the clinic, child needs religion. If you take the child to church, if you used to take your child to church at the time, and then now you are in the UK, again, you can take a letter from the priest to say, yes, when you were in Ghana or you were in your country, you used to attend church service with the child, but since you left, the child is brought to church by somebody else, but you call to check on their progress. That is also another thing. And some other documents that will prove that you are the only person that is responsible for making the major decision. It's not every decision because you are not there. You are not in Ghana, therefore you can't say you make every decision. You don't decide what the child should eat. You don't decide the shirt or the dress the child should wear every day because you are not there. Somebody does that on your behalf. So somebody does the day-to-day running around, but you make the major decisions concerning the child's life. So these are the things that you can use. Letter from the school, letter from the church, letter from the hospital, letter from the person who is looking after the child, custody order. Use all of this to support your application. Thank you. How can you get your right to work permanent residence when you came with a student visa but didn't school? Well, Mr. Dambre or Bra Emmanuel, well, the government has stopped even students who are actually attending, so switching to other routes such as the health and care until and unless they finish their school successfully. In the case that the person hasn't been to school or hasn't attended a university at all, the law does not prevent them from switching to family route. If they have a relationship or if they're in a genuine relationship or they have a child, it is possible for them to switch to that option, to that rule. Maybe as a partner, as a partner or spouse, or as a parent, they are able to switch into that category. So those options are still there. Those ones, nobody can prevent you from marrying or prevent you from having a child. If you fall in any of these categories, then of course. Or if this person, for instance, who didn't go to school, gets into a relationship with another and that person has a child, there's a genuine relationship between the man, his wife, and the stepchild, of course, you can again apply based on your stepchild under Appendix FM Section EX, Appendix FM FLRFP of the rules that you are either a stepchild to this child, or you are the father to the child, or you are married to somebody who is in the UK legally to switch to get your leave to be in the UK. Hello, Mr. Echo. Please can one add his wife and kids who are yet to come when applying for indefinite leave to remain? Oh, unfortunately, you can't do that. You can't do that until they are in the UK. I mean, if there is any section on the form that asks about family members outside the UK, yes, you can add their details to the form, but the decision will only be for you, not for them. So let me say it again. If there's a section on the form that asks for family outside the UK, and you have a wife, you can put your wife, and you have children, you can put your children's details there. But the decision will only be for you, not for them. If you want them to come to the UK, then you have to make a separate application, entry clearance application for them to come and join you here in the UK under Appendix FM Section EC C P. I'm sorry, Appendix FM Section EC hyphen P, and then Appendix FM Section EC C. They will join you here in the UK. Hello, Mr. Dennis. I would like to know with the skilled labor, skilled worker, the department is working and the man is the dependent, sorry, well, he put department. The dependent is working and the man is not working. When it's time to renew, will there be problem or it can't be possible? Yes. Um, actually been looking for, I understand workers, skilled workers are now able to work with another company. I have taken time, I have gone through, I have researched, but I cannot see the specific date on which that is effective. I haven't seen it. Maybe I am looking somewhere else. So until I find that, I will say yes. Until and unless the main applicant is working, the dependent work does not save the main applicant. This is the example I always give, and I would always give this. The dependent is based on the main applicant. It's like a tree that has a branch. A tree that has a branch. If the branch is off the main tree, the branch will not survive. And if the main tree dies, the branch will perish, the branch will die. So, in the case where the main tree, that is the main applicant, doesn't have roots, and the root is to be working in the UK with the company that brought you. So, if the main applicant doesn't have that connection with the main sponsor, it means technically the main applicant has no roots in the UK. And if the main applicant has no roots, a tree that does not have any roots, it withers. And if it withers with the branches. So if the main applicant cannot or is not working, if it gets to the time of renewal, it will affect their application. And if it affects the application of the main applicant, it will affect the application of the sponsored person, of the dependent as well. So I would advise that if you can switch, please switch. It's not easy, I know. I know it's not easy. A lot of people come to me seeking to switch, but they don't have sponsors. But if you can, please switch so that your dependent will switch with you. Then you can both work. So when it gets the time to renew, I'm sure you will have no problems at all. Candy Berry, do I need to go back to Ghana to process my partnership? It depends on your situation. Do you need to go back to Ghana to process your application as a partner? It depends. If you are in the UK and you have a valid visa, you are in the UK, your visa is valid, not visit visa. It's maybe a student or so. it is a valid visa, which is not a visit visa. You are able to apply in the UK to switch from the visa you have to the spouse visa. No leave, no problem. But if your visa is expired, if it has expired, then you can only apply in the UK if certain conditions apply. We call it EX1, exception 1. EX1, which is there is a child involved. If your wife has a child, then that applies. You can apply here without going home. If your wife doesn't have a child, but you have a child from outside the relationship, you can of course switch to your child without not being on your spouse. You can do based on your child first, and then you switch to your spouse. But if you and your spouse also have a child, seriously, you can go straight without having to go out of the UK. So either your wife's child or your own child, or you and your partner's child, you don't go to Ghana. You do everything here in the UK. The second exception is if there's something we call EX2. EX2 is if there is any serious medical problems, serious medical problem, and because of the medical condition, you cannot ask your partner to leave you, or you cannot leave your partner, which becomes an insurmountable obstacle. The insurmountable obstacle is the medical condition. You cannot surmount that, you cannot go over that obstacle and leave your partner and go to another country before you come back. If that is the case, if there is an insurmountable obstacle, example medical problem, you can apply here in the UK. If there is no child, if there is no insurmountable obstacle, you have, and your visa is expired, you have to go back home, stay home for 1 year before you apply to come back to the UK. Let me say it again. If visa is expired, if there is no child, if there's no medical problems, no insurmountable obstacle, you have to go back home, apply before you come back. Stay home for 1 year before you can come back. Thank you. Hello, Nana Kofi. Good evening. Hi, good evening. My brother came to the UK with his wife as care worker and have not been working for 5 months now. But Home Office have sent her an email that they should leave within 60 days. Is there any possibility for them to switch to another sponsor? Yes, there is a possibility. Within that 60 days, they are still here legally. They are still in the UK legally. Legally. They are still in the UK as people who are here in accordance with the rules. So if they get another sponsor, they can switch to that sponsor, and then they will still continue to be in the UK. But if they wait until the 60-day expires and they don't have a sponsor, then they become overstayers, and that makes their life very difficult thereafter. Hi, Mr. World. My cousin has lost his BRP that he recently renewed. He didn't open the envelope that contains the BRP. What should he do? Your cousin lost their BRP. He didn't even open the envelope before the BRP got lost. Whoa. The BRP that he recently renewed. He didn't open the envelope that contained the BRP. What should he do? Well, what he should do is this. If it is lost, he should report it lost. Did he lose it in the bus? Did he lose it on the train? Did he lose it on the coach, the tram, or was it stolen? He can notify the police. He can report to the police. Normally, the police will not give you a report. These days, the police don't give reports for lost items. If it is a stolen item, they will give you report. But if it is a lost item, it is different. Lost is different from stolen. But go to the police, report to them that you've lost your item. Take note of the date you went to report. And then you can then write or apply to the Home Office to cancel the card, to report it lost. It will be cancelled. Even though you don't know the number, you can still get it cancelled. With your name, your date of birth, the Home Office can cancel the card. Once they cancel the card, you are then able to apply for a replacement. So three steps. Report it either to the police, London Underground if it got lost on the London Underground, Transport London, Transport for London if it got lost on the bus, on the tram, on the coach, wherever it got lost, report it to that authority. They will send you an email or a letter to that effect. With that, report it to the Home Office to cancel. That you've lost it, they will cancel it. After that, you apply for replacement of your biometric card without any problems. Good evening, Mr. Weld again. My cousin asked, oh yes, I've just answered this. I've just answered this one. Albert Owusu Tenkrang. Hi, Mr. Tenkrang. Please, I'm a student. I have gone through the steps to view my status in the UK, but I'm unable to view. This is the result I received. We cannot find your current status in this service. The question is, are you still in school? If you are in school, if you are actually attending, then this is an error. You can contact the Home Office to rectify the error. But if you did not attend, then it means that the university has informed the Home Office that you did not attend and they have curtailed your leave as a student. That is why probably this information is showing that we cannot find your current status in this service. That is, if the university informed the Home Office that you didn't attend, even though you are here as a student, but you didn't attend, the university informs the Home Office will cancel your leave to be in the UK. So the question is, are you a student? Are you attending? If yes, and this is showing, contact the university to contact the Home Office, or you contact the Home Office direct. Are you a student? Are you attending? If the answer is no, then the Home Office have probably cancelled your leave to be here. Canterbury, I'm an overstayer. Do I need to go back to Ghana to process my partnership marriage visa with my EU partner? What if he's rich? Well, if the person is an EU national, okay, if your spouse is an EU national and you married before 31st December 2020, you don't have to go home. You do everything here. So the key date is 31st December 2020. You don't go home, you do everything here without any problems. Let me say it again. If you married before 31st December 2020 to the EU national, you married to the EU national, you don't go home. You do it here. If you married after 31st December 2020, and even though the person is an EU national, you still have to go home unless you have a child with your partner or your partner has a child. In that case, you don't go home. If the person is a British citizen and you have overstayed, again, if you have a child or your partner has a child, you have a child with your partner, you apply here, you don't go anywhere. You apply in the UK. But if there is no child, one, you have overstayed. Secondly, no child. Thirdly, no medical condition, then you are required to go back home to process your application before you come back to the UK. And when you go, you are expected to be out there for 1 year, 12 months before you come back to the UK. So that is for your information. Hello, Zarak homeboy. My life. Well, I live with my partner. Does not. Okay. Okay. You want to say I live with my partner, not wife, but she has 5 years under me. Can she have indefinite to live in the UK? She has 5 years in 2019 and have children with her. Um, Let me say it again. I live with my partner, so we are not married. Okay? She has 5 years under me. All right. So I believe you are an EU national. If you are not an EU national, I believe you are a British citizen or you have indefinite leave. And she got the 2.5 years, 2.5 years. If it is 5 years straight, then that's EU, I'm sure. If it is 2.5, 2.5, then that is under the UK law. Can she have indefinite to live in the UK? She has 5 years in 2019 and have children with her. All right. Yes, it of course again depends. Now, if it is under the EU law, yes, she can get her indefinite leave after showing that or proving that she's lived in the UK for 5 years as a partner. That is possible. If you are not an EU national, you are a British citizen, or you have indefinite leave to remain, and she had a 2.5 years and another 2.5 years under the 5 year route, yes, she will get her indefinite leave to enter after that. But if she is on the 10-year route, then she has to finish 10 years. So we need to know, is it under the 5 year route or under the 10-year route? That will determine. But in all cases, as long as there are children or there's a child involved, I believe she will get her indefinite leave to remain eventually. Okay? Don't ask no. TV. I'm trying to bring my cousin who is 19 to the UK. What's the best possible process to go through? Thank you, Don. If you're bringing your cousin who is 19 years old, remember he's an adult. Once the person turns 18, they are an adult, they are no longer a child. And therefore, 19 is an adult. You haven't told me if you're a British citizen or you're an EU national. If you're an EU national, you cannot. Because the laws have changed, you cannot bring your cousins anymore. They are classified as extended family members. Uncles, nephews, nieces, aunties, brothers, sisters are all categorized as EU national extended family members. So they you cannot bring. If you're a British citizen, unfortunately, because he's gone past 18 years, you are not able to apply for him to come. If he was under 18 years and there are significant compassionate circumstances for them to come, that application could have been made under paragraph 297 of the immigration rules. But in this case, we don't know whether you're EU or a British citizen. I need a little more information to give you a straight answer with this particular one. Thank you very, very much. Mr. Sego, how long does an appeal to join my husband take? Appeals can take a very long time. Appeal can take 8 months, 9 months, a year, or more. Appeal can take a very, very long time. So that is for you. Now, what we have to be aware of is when we're talking about appeal, we're looking at it, people look at it from the date they made the application. No, don't look at it from the date of the application. Look at it from the date you submitted the appeal or you lodged the appeal. You have to lodge the appeal and make the payment, and then if you can track the trend on the timeline, the court will get back to you. The Home Office will have to send some documentations. You also have to prepare your bundle, send it to the court. The court will ask if you have any hearing needs, etc., etc. Hearing requirements, you need wheelchair, you need access to the court, you need an interpreter. All of those take a very, very long time. But eventually it will happen, but it can take even a year or more for appeal to be heard. Yes? Okay. Evans Arthur. A woman came to the UK through EU family route by marriage. She has not gotten her indefinite leave but given birth with another man. What becomes of her and the man she got pregnant for? Right. Very interesting. Is this. Now, if she came to the UK through an EU national, she's still a family member of the EU national. Now, even though she is giving birth with somebody else, that is let's classify it as um, relationship outside of the marriage. Okay, as long as she is not divorced, from the EU national, she remains a family member. There's a case called the case of Ashe to Diata. The case of Ashe to Diata says even if the parties live at a separate address or for whatever reason there's a dispute or misunderstanding, it does not mean that they are not married. But particularly, if they are not living under the same roof, it doesn't mean that the relationship is over. She still remains a family member of the EU national. So, what I will say is this: she would have to apply for her indefinite leave to remain. I don't know whose name, which father's name is on the birth certificate. If it is the EU national's name on the child's birth certificate because she's still married to the EU national, she can get indefinite for herself and the child. Or she can wait. Once she gets the indefinite, she will then register her child as a British citizen under Section 1(3) of the British Nationality Act of 1981. So she can apply for her indefinite leave alone, or apply for herself and the child, or apply for herself alone and later apply for the British citizenship for the child. That is for the woman and the baby. The man with whom she gave birth or with whom she had a relationship and gave birth, if he hasn't got any stay in this country, once the child becomes a British citizen, the father of the child, that is the second man with whom she had the child, can then, of course, if he's got his name on the child's birth certificate, make an application based on his child because the child is a British citizen. In any event, if his name is not on the child's birth certificate and it later comes to light that he is the father of the child and he has a DNA done, his name will go on the child's birth certificate. Then he can also again apply for his leave to be in the UK based on the fact that he is the father of a child that is a British citizen. So either way, he will get his stay. One is shorter, the other is a longer route by doing DNA, having his name on the birth certificate, etc., etc. Then he applies for his leave to remain. The other way is if his name is on the birth certificate, of course, the woman gets her indefinite, applies for British citizenship for the child, and then the father can also base on the child to get their leave to remain in the UK. Mr. Tomofusu, how even so woman. Okay, I've just done this one. Tomofusu, hi. Please, can the main applicant use his or her 20 hours in a different field, example, Uber driving, from the sponsored job? Well, that is what I said I have been searching for. I still have to look for. Because last week I promised a gentleman to give you an update. I haven't still found anything, so I don't want to go into that territory. If I confirm that yes, they are able to work in any other field at all, then of course they can. But until then, please bear with me. I will still get my research done and give you the accurate information. I don't want to mislead anybody on this platform as far as the law is concerned. Hello. I live with my partner, not with my. Yes, I have answered this one too. I've answered this one too. She's not your part. She's your partner, but not your wife. Can she get an indefinite leave to remain? She had 5 years in 2019. Yes. So if it is under the EU law, if she had 5 years in 2019, then 25 years is now 2024. So she can apply if she's an EU national. Vivi, thanks for the good work. Thank you too. I'm very grateful to you too. Thank you for thanking me. God bless you. My question is if one has written IELT at home, can they use it to get a job in the UK in the NHS? If the person is in the UK already, yes, possibly they could look for that. They could use that to get a job or apply for a job in the NHS. It depends on which sector you want to go to. But if you are back home in Ghana, the IELTS alone is not enough. You have to go to the NHS website. Now, I told some people some time ago that go to the NHS website, look for jobs, and then email them to see if they have the sponsorship license to sponsor nurses from abroad. I am informed that They are still recruiting nurses from. That's what I'm told. I've been told that NHS recruits nurses from Zimbabwe, and I'm sure from other countries as well. So if you are able to liaise with them and they are able to confirm that they have the sponsorship license, then of course with the IALT tests, you'll be able to come to the UK. If they have the sponsorship license and the test you've written meets their criteria, you will then be able to apply to come to the UK to work with the UKNHS. Thank you very much, Don. You are a British citizen. Okay. So in that case, the response I gave with the aspect of the British citizenship would apply to you. Thank you. My any news? Any news? Is there lawyer any news regards to BRP in 2025? The BRP is actually going to end all the cards in 2020. All the cards will be ending in 2024, 31st December. I did that. I talked about that last Friday. That all the BRPs are expiring on the 31st of December 2024. That does not mean that your leave is expiring. Your leave still goes on, but it's the BRP. So we'll talk about the e-visas next week. How the Home Office has started sending emails to people to apply for e-visas. They should go online and register for their e-visas. So you now have to go online, create an account, and then the Home Office will be able to, of course, they will do then is to create your data, everything. You can check your data, everything online. So you don't have a problem if your visa is still valid. 2025, no problem. But I would advise that please keep checking to see the exact date that your leave expires so that you don't go beyond the expiry date because they put everybody's leave on 31st December 2024. Hello, linking to your answers. You completed school in 2023 and given 2 years visa. First year in class and the second year on work placement, but didn't get a company for my placement. Could it be the reason for me unable to view my? No, 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 no. That is absolutely not correct. Now, if you are on the 2 years, if you are still on the 2 years graduate visa, you are supposed to have your details online. For the 2 years graduate visa, it has nothing to do with any employer at all. You don't have to have a sponsor. No sponsor is required. So whether you are working or not, it does not mean that you are here unlawfully. So your status should still show on the system. So please liaise with the Home Office and tell them that you you try to check your status, you try to check your biometric details, and you are not seeing, they will be able to amend it if you still can't find it. So please try it again, try it again, try it again, and I'm sure they will rectify it. It's got nothing to do with you working or not working right now. Hello, Mr. Buampong. I want to ask that after your application is denied, whether or not appeal, how many months or days can you apply on a different route? Okay, whether or not you appeal. Now, if your application is denied and you appealed or you didn't appeal, you want to know when you can apply on a different route. It depends on the category in which you are. If your application is not successful, you didn't appeal, you have a child, you can apply today based on your child. You have a spouse that has a child, you can apply today based on your child. You still have some sort of leave, you can still apply. Obviously, if you didn't appeal, it means that probably you don't have valid leave. There is no fixed timeline, there is no time limit. You can always apply if there is a change in your circumstances. So that's the word. As soon as there's any change in your circumstances, please put in application if you fall within a certain category of the rules or under a certain provision of the rules, you can apply for your leave to remain. No months, no timeline. Thank you.
All right, lawyer.
Thank you.
I think let me take this last one, and then we can wrap up. Okay, let's take this one.
All right, Kwesi Treme. Hello, Mr. Treme. I came with my wife last year on a skilled worker route, but we applied for the British Army when we were in Ghana, and we have just received some mails from the Army recruitment team. I want to know if she still qualifies to join the British Army. I'm the main applicant, and she is my dependent. Yes, if she's a dependent, of course, nothing stops her from switching. Now, there are some categories that you can't switch to or you can't switch from. But in this case, I don't think there's any restriction on her applying to switch to the British Army. Um, so I would say she should go ahead. If they have any difficulties or they claim she cannot switch, they will give you a reason why. But I have not read anything specifically which says a dependent cannot switch. I haven't read anything specific that says a dependent cannot switch. Because if I looked at the student route at Tier 4 recently, a dependent can switch. Only people who cannot switch are people who are here on a visit visa, temporary admission, visit visa, temporary admission, or immigration bail. Those who are here on as a student, as a carer of a child student, those who are here as seasonal workers, or people who are here as domestic workers in a private household. These categories of people cannot switch to the student route or to other routes. I haven't seen anything that says that she cannot switch to the British Army. So she should go ahead, follow the procedure. I believe if she qualifies, they will let her know. If she cannot switch, they will let her know. If she switches, fine. If she can't switch, in any case, she's already as a dependent in the UK. So please, I would say yes, go for it. Go for it. How long does it take for a woman who got married to an EU national under EU law to get her indefinite leave? If they married whilst they were here in the UK, if the two of them were in the UK, or if the woman was in the UK and the marriage took place, it is 5 years from the date of the marriage, not the date on the card, but the date of the marriage. That is it. If she came to the UK from outside, then the 5 years starts from the date she arrived in the UK. Let me say it again. If she married, she was given EUSS family permit to come to the UK. The 5 years starts from the day she arrived in the UK. But if she was here before they married, the 5 years starts from the date of the marriage. So once the 5 years is up and they can prove that they've been here for 5 years, GP records, bank statement, pay slips, P60, gas, water, electricity documentations can prove for 5 years. Of course, you know, you know how to make the application. You can go ahead. She should be given the indefinite leave. Of course, with the evidence of relationship to the EU national. Canada must obey. Hi. God bless, lawyer. God bless you for the insightful sessions. Thank you too. I'm really grateful. God bless you. I really appreciate you. My fiance, who is a British citizen, got divorced by his ex-wife 7 years ago. Unfortunately, the certificate of divorce was sent to him. You want to know if he's able to get the divorce certificate. If they divorce in the UK, yes, it is possible to get a divorce certificate. There's something we call decree absolute search. Decree absolute search. If the divorce took place in the UK, all the records are there. If you do a decree absolute search, it will be provided for her. Then she can use that, or he or she can use that to make an application for you if you want to come to the UK. But if the divorce took place in Ghana, then of course you have to contact the um, the the court where the divorce took place. I'm sure they'll have records of it. I hope they'll have records of it. I can't trust very much, but I only hope that they have record of it. And then at least, even if you don't have the original, they can give you a certified true copy. A copy with a stamp on it, which is a certified true copy. That is good enough for you to make your application to join your partner here in the UK. Thank you very
All
much.
right, lawyer. Thank you so much. Those asking of lawyers' contact, his numbers are on the screens as you can see now. So you can contact Wise Smart Solicitors, office line and the mobile number. So, lawyer, thank you so much for joining us today. God
Thank
willing,
you.
next week meet again. Your office location, those who are in UK that they want to come and visit you.
My
Uh,
office, yeah, thank you. It's not in the Dawson Market. It's near the Dawson Market.
but I've not said anything.
I yes.
Today I've not said anything. I've not given any location. I said your office location.
Oh, that's what you
Opposite
did.
McDonald's. The opposite McDonald's.
It's behind
The
the
print,
market.
the print house. The
Yeah,
print house, they don't print visa.
we
So
don't
you
print
give the
visa.
location.
We don't print visa, but we print our letters and we give it to you. You take it there, they print your visa for you to come and join us in the UK. Thank you very much. DJ, thank you so much. I really, 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 really appreciate you. Thank you for all the good work you're doing. Somebody came to me yesterday and he was full of praise for you. Full of praise for
Oh,
you.
really?
Yeah,
Did
yeah,
the
yeah.
person did the person say tour? Tour, tour,
He
tour,
said
tour.
to her, when he was leaving, he said to her, very interesting. He
So
told,
so tour is the promo code there. When they get they say tour, tour, tour.
yeah. Yeah, he said it's a Tema boy. He said it's a Tema boy, so he knows you very
Oh, I
well.
see.
Yeah. He said DJ Nyami, I've been following him. He's a Tema boy. We know we've been hanging out. I mean, he said very, very, very pleasant things about you. So I can
Oh,
only
nice.
say you're doing a good job. Thank you. Keep it up. I am sure greater things are ahead. Greater things are ahead. More grace to
Sure.
you. More grace to you.
Sure.
I'm
So
glad.
you give the address, the
Yeah.
postcode,
Yes.
a location.
Yes, thank you. It's Wise Smart Solicitors. Wise Smart Solicitors, number 318 to 22 Ashwin Street. Number 8 to 9, the Print House. 8 to 9, the Print House. 18 to 22 Ashwin Street. 8 to 9, the Print House. 18 to 22 Ashwin Street. Dalston, London, E8 3DL. Dalston, London, E8 3DL. E8 3DL. That is
Mm.
the address. Telephone numbers are on the screen. It's +44 2080 165 384. That is 0044 The mobile number is 079 31
Mm.
079 These are
Mm.
details. Feel free, contact us, call us. If you can't travel from wherever you are, we are doing telephone consultation. We're doing FaceTime consultation. We do FaceTime, we do Zoom, we do all this. We can have, you don't have to travel all the way from Wales. Somebody came from Wales the other time to see me on a Saturday.
Wow.
Was fine, but some of the things we can do it without you having to travel all that way to come down. Especially if it is consultation, we can do it over the phone. It saves you the travel cost and time a lot. But if we need to progress with the application, of course, if we get the documents, again, we can do it without you having to come. Once we do all the necessary checks, we can do it. Or preferably sometimes you come, we sit down face to face, we finish everything before you leave the office, everything is sorted. So thank you. I'm grateful, DJ, once again. God bless you. To all our listeners, all our watchers, we appreciate you. God richly bless you. God willing, next week we shall meet.
Thank you so much, lawyer Wisdom Akao, Wise Smart Solicitors. But lawyer, I'll be starting the US. I have US immigration.
Good.
Uh, I have US immigration, like just like you,
Like
solicitor.
Apoku.
It's not Poku. Poku is busy. Poku they may try number cry. No, a busy woman.
It's
So
very easy though.
I have a new lady. I'll be bringing her soon, maybe from next week. So those
Very
who
good.
are interested in this immigration matters, I mean, getting all the filler and all that. So people are asking me. People do ask, so Nyame, when are you
On the
bringing
US.
these
Yes, I'm on the
US?
US. Very
So, okay,
important.
I'll do that.
The US is
So
a
from
the US is a bigger fish. The
yeah,
geography,
yeah, yeah.
the
People want to
geography is
get more
large.
filler.
Yeah, geography is large.
You
So
know, your people now they are tightening things. So Charlie, your country some
yeah,
way.
it's
Your
everything.
people are tightening all
Everything
corner, all
is being
corners.
screwed. Everything is being screwed, and it's just becoming really, really
So
difficult.
so Charlie, guys, I'll be bringing you updates on the US immigration matters and all that, from how to apply visa, how to get this B1, B2, your permit, your what. I'll be doing all on this channel. So make sure you subscribe to SBTV, our YouTube channel, so that you get notification. Yeah, join us. Thank you so much for watching today, guys. Big shout out to you all. Also subscribe to our English channel, SVTV International. Just type SVTV International. You are there. Make sure you watch our English interviews. As for SBTV Africa, there, local base. Local base. Thank you guys so much. God willing, next week I'll see you again here. But enjoy our videos. We have more videos we uploaded today on our YouTube channel. So those watching us on Facebook, sometimes you see the teasers. Make sure you go on our English, you go on our YouTube channel to watch the full video. All the shots, the teasers that you see on our Facebook page, there's a link on it that will lead you to our YouTube channel. Some people they don't reach, so they will say, "Oh, your videos are short," but there is link there. All the short videos that you see on our Facebook channel, there is a link at the top. So if you click on it, you can watch the full video on our YouTube channel, SBTV Africa. Thank you guys for watching. Big shout out to all those who join us today. Let me see if I can give shout outs to all those who join us today. I bet you just drop your question or your comments. You are late. Next week, try to come early so that you bring your question. The lawyer will answer you. Abeto Usu, I think, right. Thank you so much for joining us today. Gordon, thank you so much. Yaro Zongo, thank you so much. Danso, Samuel Danso, thank you so much. Linda Sante, Don Arsenal TV, thank you so much. Yebua World, thank you so much. Vivi, thank you so much. Zarak Homeboy, thank you so much. Kevin Ejapon, Tombo Fosu, thank you so much. Evans Atta, Richmond Sego, thank you so much. Candy Berry, thank you so much for joining us today. Who else? Nana Kofi, thank you so much. Beatrice Owusu, thank you so much. Kojo Dennis, thank you so much. Echo Osley, thank you so much. Emmanuel Dampre, thank you so much. Elinda Santi, thank you so much. Princess, thank you so much for joining us. Tom Ofosu, Dennis Abojo, thank you so much for joining us. Bazana Daniel, thank you so much for joining us. Is it Piscoa Ousu? Piscoa Ousu, thank you so much. Bright, thank you so much. Then is it Raman Nisa? Is it Ramansa? Ramisa? Hey, Charlie, Dini, he heavy too much. Is it Raminisa? Thank you so much. Or Ramanisa. Well, if I don't mention it, well, forgive me. Thank you so much. Some of the names, Charlie, your nicknames there. Canada must obey. Thank you so much. Say keep it up, DJ. Thank you to Yaopoku. Thank you, DJ. God bless DJ and lawyer. Thank you guys all. Augustine, thank you so much. But go and watch. One thing is that you guys don't support the thing where you don't share our videos. That is the problem. If you are watching us on Facebook, it will not cost you anything. Just share so that somebody to watch and learn. We don't share. Just share the video. It will not cost you anything. Sharing on your page to invite your friends who are following you to also see what's happening. We are learning. So most of you guys, you are watching us, you don't share, please share, and also subscribe to our channel on YouTube. Follow us for more updates. We'll be bringing you more content on SBTV Africa, SBTV International, SBTV Africa Foundation. Let's help together. Charlie, thank you guys all. Enjoy your weekend and enjoy our videos. I'll be dropping a fresh video after this vibe, but we have more videos on our channel that you will learn from others. Charlie, all the best. Big ups.